Good day, everyone. Today I will be reporting the basic principles of international law treaties. Treaties are the cornerstone of international relations. Understanding key principles is essential for navigating this complex legal landscape. Treaties are fundamental instruments of international law, establishing agreements between states. They govern a wide range of issues from trade and human rights to environmental protection and nuclear non-proliferation. Understanding the basic principles of treaties is crucial for comprehending the intricate web of international relations and the legal framework governing local interactions. So the first principles is Pacta Tertis Nec Nocent Nec Prosunt. It means that treaties neither harm nor benefit third parties. Binding agreement. A treaty creates obligation only for the parties involved. No third party rights. Third parties cannot benefit from or be bound by that treaty. The principle has significant implication for international relations. It ensures that states are not compelled to adhere to agreements they were not party to. It also reinforces the idea of state sovereignty, allowing states to freely enter into binding agreements based on their own interests and priorities. And the second is pacta sunt servanda, meaning that agreements must be kept. Good faith. Parties must perform their obligations in good faith. Article 26 of the Vienna Convention. These principles is enshrined in international law. Treaty enforcement. States are expected to comply with their treaty commitments. The principles ensures that international agreements are respected and upheld, fostering stability and predictability in the global system. It promotes cooperation and compliance, allowing states to build trust and engage in mutually beneficial arrangements. And the third is rebus sic stantibus, means that things standing does. Fundamental change circumstances must change drastically since the treaty's creation. Second is unforeseen circumstances. The change was not anticipated at the time of this agreement. Third is essential basis. The changed circumstances must have been a crucial factor in the agreement. Radical transformation. The change must fundamentally alter the treaty's obligations. Rebus sic stantibus exceptions. Boundary treaties. These treaties are generally not subject to rebus sic stantibus. Treaty provisions. The treaty itself may exclude the application of this principle. Good faith. States must act in good faith when invoking rebus sic stantibus. The exceptional circumstances may arise after a treaty is concluded. These circumstances, unforeseen by the parties, may radically transform the extent of obligations under the treaty, potentially rendering it incredible or impossible to perform. Rebus sic stantibus termination. Ground for termination. Rebus sic stantibus can be used to terminate or withdraw from a treaty. Notice for other parties. The invoking party must notify other parties of its intention. Dispute resolution. Disagreements about the application or rebus sic stantibus can arise. Interpreting treaties. Vienna Convention provides guidance on treaty interpretation. Ordinary meaning: the text should be interpreted based on its normal meaning. Intention of the parties: the shared intent of the parties is considered. Contextual analysis: the surrounding circumstances and relevant international law are taken into account. Key takeaways: Pacta sunt servanda, foundation of treaty law. Rebus sic stantibus, exception to pacta sunt servanda, but with strict conditions. Treaty interpretation: objective and based on the Vienna Convention.